A very warm morning to one and all present here. I, Ankita, the executive member of student section, welcomes you all on the behalf of Indian National Bar Association. Our topic for session 1 is copyright issues in online broadcasting, the conflict between paid content and free access. On the topic, copyright is a legal right which grants the creator of the work exclusive right to grant permission onto who and in what sense can use his original work. Our moderator for the session is Mr. Shantanu Mukherjee, who's an advocate and head of chambers, ex-Lege Chambers. Our speakers for the panel are Mr. Sachin Kalra, Deputy General Counsel, Hindustan Times Media; Mr. Rodney D. Ryder, partner, Scriptboard, advocate and legal consultants; Mr. Sanjay Tandon, Managing Director, Indian Singers Rights Association; Mr. Naveen Kanwadia, Legal and Regulatory Star Groups. I'd like to present the rules of the conference. Each speaker would be given the time of 10 minutes. Now, I'd like to hand over the mic to Mr. Shantanu Mukherjee to further conduct the panel discussion. Also, I'd like to invite all our speakers on stage.
A very good morning. Very good morning to all of you. Thank you very much for coming over when a lot of other programs are happening today. Today being National Constitution Day or the Constitution Day. Thank you for introducing. We have today a very distinguished panel. Thank you for setting the rules, as you said, but I take it from you, not just as the moderator, but also as the chair. So what I would like to do is make it as interactive as possible. So each of the distinguished panelists will speak around 5-6 minutes, not 10 minutes. So that's how I would like to do it. Questions would be coming in the second round. Initially, how I would like to do is each of them would present their thoughts as to, I would introduce the topic, I will put it in perspective, and then I would let them absolutely whatever they think they bring on the table from their experience and from the work that they do to start as introductory remarks. So then I would like to open it up for questions, and in between we'll play in and out to see how we can make sure that we gain maximum from today's discourse. See, if you see what is happening today, we would see that we are actually living in an online world, thanks to the mobile broadband access. And in India, it is spreading fast, not just in urban areas, it's also in rural areas. It has the broadband connectivity is spreading. It's a matter of competition between service providers in the urban area on speed of connectivity. And when speed of connectivity comes, the content, the disperse of contents also comes in. When we see contents coming in, we see sellable contents. So everyone is interested in the monetization of the content. And the content is not just a sort of presentation where it is a sort of entertainment, but also advertisements. So there's content, visual read contents, and there's audiovisual contents. And then there's advertisements. The business models are changing. Business models have changed. The business models are changing. And we see online streaming, which is more and more becoming popular. With this, we already, for quite some time, we had the cable networks, over-the-top services. Now, even they're getting very streamlined and very focused. That's the scenario. Of course, we have players like Netflix. We have players like Amazon Media, with the many other names I can carry on. What is happening is the content is reaching to you in your personal space through small devices in your personal time. That's fantastic. Everything is very good. What about the protection of the content? You have so much of content which is already flowing everywhere and all sorts. As I said, the content is not just entertainment, it's also advertisement. The content is of all nature, and also news. Well, news is becoming entertainment too. So the point is, it has become nightmarish, absolutely nightmarish, to protect these content. And there comes the issue of copyright law. The copyright law, we see, has always been in action to protect the intellectual labor which goes in creativity. When we see copyright law and the creativity which goes in, it is not just protection of a certain single creator. We see there are script writers, we see actors, we see singers, performers of all sorts, and I can carry on with the list. Each of them, they have their own rights. Each of them need the necessary basic protection so that there is no replication. I just mentioned about online broadcast. It's a focus area. Now, in online broadcast, the possibility of replication and fast dissemination of the replication happens just in such a scale and such a time that protection really becomes a challenge. In that sort of scenario, what do we see in India? What do we see the law, how the law is keeping up? The Copyright Act 1957 took care of the protection for a certain time. And then, of course, we see it was regularly amended in 1983, 84, 1994, and 1999. And then we see the Copyright Amendment Act of 2012. With that, we see completely nearly a new modern law. So typically, if you talk of copyright, as I mentioned, copyright, we say, and duly so, is a bundle of rights. And if we look at the 2012 law, we see it is literally protection of the bundle of rights. And when we say bundle of rights, why I say that 2012 law is literally a protection of the bundle of rights, because we see there is provision, institutional mechanism for protection and I would say access and benefit sharing of the monetization revenues of the rights to all participants, including performers, singers, etc., through statutory licensing. Well, we can debate on whether it is working, not working, that's a different thing, but the provision is very much there. The new 2012 law also takes care of, expands the horizon of copyrights over broadcasting. So in that scenario, we see that conservative, as Indian government has been all through, has moved a step ahead and acknowledged the technology disbursement which has happened, and India signed. Of course, A lot of work has gone from many sectors of copyright industry. The Indian government has signed the World Intellectual Property Organization's Copyright Treaty. They have signed the WIPO Performers and Phonograms Treaty. So the coverage is pretty comprehensive, if I might say so. But, unfortunately, still there's a but. Unfortunately, we still see there's a lot of issues of piracy, a lot of issues of hacking, unauthorized online streaming, there's license faults, and I can carry on with the list. So this is the setup we are sitting today while discussing. And then there's interesting issue of people, a section of the society coming and saying that, well, you know, it's access, it is the price, it is too pricey, it is not reasonable, and so that's why the affordability issue comes in, and that's why people are copying, that's why people are pirating, that's why people are doing all that. But mind you, they would love to see they would love to watch an online broadcast free of charge. They will do that on a device for which they don't mind to pay the money. And the device can be pretty expensive too. So they would not like to pay a fractional amount for the content, but they would like to pay higher for the device. So the question as to whether we really have this problem of affordability, I don't know. So then again, then there's a section of the people who'd say, the copy left would say, everything should be free. Whether it is a business model or not, everything should be free. So these are the questions I am placing before the learned panel. And then I'll request them, we'll sit on and we will carry on discussing. The first thing what I would request one of my distinguished panelists to do is Rodney. Mr. Rodney D. Ryder is quite an expert, legal expert in this field. And so, Rodney, if you can lay the legal scenario out, how it is, how the law is addressing these issues, why there was a need to change the law, and where we are, what are the gaps, how do you see moving forward? With that, I hand over to Rodney.
Thank you, Chairman, sir. I think one can take a couple of themes from your introduction. And one of the themes is the tumult that comes, the chaos that came with copyright and copying to begin with. So if I were to share some random thoughts, from the invention of the printing press, the Statute of Anne to the Berne Convention, you had several eras of chaos, but now we find those eras of chaos sandwiched into the last 20 to 25 years. What do I mean by that? I mean that at the turn of the century or slightly before, we had the Berne Convention, which sorted out once and for all what the minimum standard was to be. And each jurisdiction, each country enacted laws on that. Then, and we built industries around what was the law then. And then came the internet. And it was clear once we were into, or even less than into a decade of the internet, that the law would not govern on its own. There would be the need for code. So we came up with, and that's the time that the precursors of our Copyright Act existed somewhere in the world. We had these treaties, and what we tried to do is put this law and technology combination into the act, which we, to my understanding, have done rather well with the Copyright Act of 2012. Now, with technological measures of protection, with digital rights management, we went further and we said, how do we regulate intermediaries? And there, the Copyright Act is interwoven with provisions of the Information Technology Act, and we look to a balance. In the middle of everything, in India at least, we had the Shreya Singhal decision, which for copyright owners and those enforcing copyright threw the proverbial spanner in the works, because now a court order was required, and there was this access ownership debate that raged. But in 2012, we also inserted these statutory licensing provisions, allegedly for radio and broadcast, Section 31D, which in hindsight, with a great deal of wisdom, were clarified in a office memorandum by the Department of Industrial Policy and Promotion, and extended on the 5th of September 2016 to the internet, which surprised many, shocked a few, and also, if I may add, delighted a few. So in my allotted 5 minutes, I would try to flag a few important milestones as we move ahead. The most important modern milestone remains the Berne Convention, from where we started, and the subsequent legislation treaties, until we now find ourselves in a rather strange position with burdening, if I may say in a little bit of seriousness, a little bit of jest, the Copyright Board with Section 31D and fixing royalties. Some of these issues are being challenged, and that leads, I think, to an exciting discussion moving forward.
We'll definitely, time permits, we'll go to the recent, not yet jurisprudence in the sense ongoing case regarding this matter of statutory license, and we are sitting in Constitution Day, and with the constitutionality of the issue, which is being quite a bit argued before the Honorable Supreme Court. We will go to that later. But the point is, thank you for raising the Shreya Singhal matter. He was referring to the takedown notices and the possibility of what is the responsibility of the intermediary, how the intermediary would be liable, and whether if there's a takedown notice which comes from the content owner, whether it should be honored, when it should be honored, how it should be honored. This is what he was referring to, if I'm not wrong. So this is an aspect of the entire discussion when it goes to online. Now, it is very interesting to see Sachin coming from Hindustan Times. For those of you who are not aware, Hindustan Times, nearly 100 years, is well known as one of the leading newspapers, I think 80 plus years. So 80 plus years, Hindustan Times had been there in India, and it has been traditionally, conventionally in print media. So the competition, the copyright issues they had attended to had been in print media. Then there's a transition into HT media, which is online. I think 3-4 brand names you have. I'm not going into that. I will let you speak on that. How do you see the transition? Because the issues, the problems grow manifold. And how do you transition from a mainstream, conventional print media copyright issues to online issues, and then take it forward? What are the problems? Where you have the generic content and the proprietary content, where the catchwords and the catchphrases and the copy of the catchphrases come in. What is news generic? What is news proprietary? I'll leave it to you on that.
Thanks, Atul. So coming to the background, we are around 80 plus years in the industry now. Talking to the digital side, we started the radio business also. We started with the digital business also. We are into advertising field, AFP business also. These are all internet businesses which started later on in the year 95, 98, and then after 2004. So coming to the point, first of all, see, if you go to background of copyright, how copyright came into picture. So in 1497, England, printing press started. And then the issue came of copyright. The person who is printing, the author who is giving his all his mind, all his things on a writing paper, how the copyright will. Then the streamline of still copyright started all over the world. How to have out of piracy, no infringement pertaining to that, all started one by one. In India, definitely in press side, we being into a major player of press media, we've been facing these issues particularly on the side of what's the fair use, what's not a fair use, basic thing which copyright says. So anything as per the Supreme Court only, in Indian newspaper long back, it was decided anything which is news or an event cannot be a copyright. The major challenge behind that, the author who is putting all his words, all his efforts towards the thing, and after that, he's been said this is all fair use been done. Similar issue which was faced by us also, I do remember, it's around 1986, 87 around. One of my editor was on a depth kind of searches for those investigation. He did investigation. The report was published, number of papers were published day by day. It was more towards the taking of women from one place to other place. One of the dramatists or author, publisher, published this drama, entire drama, whatever was in the exam paper. We challenged this before the Supreme Court or High Court, all over there. The High Court said that, so that was an event, it's a drama which has been mindset. So it was a differentiation was given to us. So these are the problems which industry face, or media basically, which we are facing day by day. Coming to the point, there was a case of Diana case also, which was a famous newspaper case which happened in 2010. Similar issue was in Diana case also, where the photograph of Diana was published by one of the newspaper agency. It was a photograph a day before which was clicked by a security guard in a common area. Then it was said it is not a fair use which has been done. The purpose of photograph was not to be used for the purpose of newspaper. This is how it makes the challenges towards the newspaper agency is there. Coming to the 2012, which we all are into, I still feel a lot to go and a lot to come. We say copyright board to be there, but multiple challenges before different courts going on. Delhi High Court said IPAB has a power to deal with the copyright issues. It's a copyright board, but IPAB don't have a member which should be a copyright member, which is a basic problem which everyone is facing today. Similar issue is with the royalty part which is going on. We are also contesting with many of the associations which are there. Copyright board said in 2014 the 2% should be a royalty fees, which is the normal fees. The agency went to the forward, challenged the High Court. Similar order is received by IB also. Still we are running with the paras because things are not collaborating. We say 2012 more of coverage of international treaties are there, WIPO and everyone. But still we need to go further. This is what from my.
Thank you very much. You touched upon a couple of issues for those who are not aware of the Indian law and what's going on. He touched upon the issues of what should be a statutory license and how much should be the percentage of royalty, which and whether in a market-driven economy, whether the royalty should be set by a government body or not. Now the point is, why today we see the statutory license coming in? The issue of those, a certain section of the creators getting all the monetary revenues and not sharing with the others triggered the entire thing. And then we see the IPAB, as he said, the Intellectual Property Appellate Board, coming in and saying that, yes, we will set the royalty. And the question before that was whether they can set or not, whether they can even talk about copyright issues or not, when there is no technical member in the board looking into copyrights. So the Intellectual Property appellate body is such where you have technical members for every section of the IP going on. That's what he touched upon. Interesting development. We can even be provocative a bit later on. But the point is now, let me bring in Naveen. And Naveen comes from the Star Group. And those who have followed the copyright, the interesting issues of copyright, telecast, broadcast, fights, handshakes, all sorts of things, Hotstar and a lot of other issues coming in, we will see that Star, as a group, had been in the forefront of the battle with the cable TV and the telecast of cable TV when there was the business of sports, if I'm not wrong. And there had been certain landmark decisions on what should be the right, who should have the right. So this is the scenario. In that scenario, Star already, you have historical wins and also certain curtailments. From there, the cable TV telecast and the broadcast, that sort of the regime, now we have a different regime, an online regime, where you do not necessarily have geographical boundaries set. The licensing norms in a situation where the broadcasting is not within your material geography. How do you address those issues? I mean, this is only one side of it. You have liberty to bring in other issues too. I would request you to take it off.
Yeah, thank you, Shantanu. Just to give a background of what Star India is, it's a subsidiary of 21st Century Fox. Fox is one of the largest broadcasters around the world, and those of you might be following news, it's in the process of merging with Disney, which combinedly would be the largest media and entertainment company in the world. So Star being the kind of a initiator of private broadcast in India. It entered India in 1991, straight after the economic policy was liberalized as an English language content provider, and then it went fully local in 93, where it started producing, not just in Hindi, but today it produces content in about 8 different languages across India, which is the highest for any broadcast agency. And then it made its move quite strategically into the digital content space, where Hotstar was launched just a few years back. And it has, since then, right from its inception, it has gone on to become one of the most downloaded applications in India, digital applications in India, and also it continues to have the highest viewership of any curated online video platform in India. Having said that, when I got the invite for this session, I read through the topic, I was like, outdated. Absolutely outdated. Why? Because we are talking about copyright and online broadcasting, something that was discussed a fair bit in the 1990s, in that decade. Today, I think we should be talking about, if I may say to my co-panelists also, digital ecosystems in copyright. Because the entire approach towards understanding rights in the bundle of rights that Shantanu had mentioned in the beginning, in a technology-specific manner, is getting dismantled at pace that you and I cannot imagine, right? What is happening is that human interaction with technology is no more external to the process of making available that technology. It actually is slowly getting internalized. And to give an example, with the advent of 5G technologies, which are expected to be anywhere between 75 to 100 times, 75 to 100 times more advanced than 4G LTE technology, which already is pretty impressive. We can imagine the kind of the troika of interaction that will take place between human to machine, machine to machine, machine to human. And within that, the kind of creativity that would emerge. Quite frankly, that discussion, because I'm a lawyer by background, but my interest primarily rests in public policy. So what's actually happening is that I don't see that realization amongst our legal fraternity in India yet. That do we prepare for such an ecosystem or not, where practically there are no lines between technologies and the manner in which content can be exploited, right? So do we update ourselves? Do we update our regime or not? Globally, there are certain precedents. I think the one jurisdiction that is kind of taking this head on behalf of creators and producers of content is actually European Union, which is updating its copyright directive. And it has caused quite a stir where I will not name the companies, but certain platforms have publicly gone on a global rampage against what is being done through Article 13 and Article 11 over there. And the bodies representing the creators and producers have rightly so challenged the kind of propaganda that is being done against it. To name the IFPI and PRS and others from Europe, who have taken up the battle. Another jurisdiction that is again acting in a way that's realizing what is happening to the technological sphere vis-a-vis copyright is actually Australia, where recent amendments have been proposed to kind of detach intermediary liability from just internet service provider, basically your infrastructure owner, your Verizon, your Sprint, your Airtel, your Vodafone, and to actually bring it to the platform. What has happened is in India, we haven't even had the realization that internet has been platformized, where the interaction between most people and the web hosting technologies is mediated through a platform. To take an example of Facebook or YouTube and others, I mean, the user-generated content platforms, specifically if we are talking with respect to content. So this is where I think the discussion ought to be at this stage, and this should be the starting point, thanks to my co-panelists, Rodney and others, to have set the historical discussion in context. But if we are to be serious about copyright, then we have to start from there. Then another thing that is happening is, organizationally, technology companies and content companies were traditionally separated, right? You had these big Hollywood studios producing content, Bollywood studios producing content, then you had the telecom companies, the connectivity technology providers, the web hosting service providers. Those are gone now. We have an AT&T merging within it Time Warner, and similar other mergers taking place. In India, it's the Jio phenomenon, where cable companies have been brought in a couple of days, and then they have started their own studio, and a lot of other content companies have been taken over. So, I mean, at the end of the day, what would remain more vital for these organizations? Their technology business or their content business? That will also decide the direction that this debate will take. So this is where I think we have to discuss, and this is where we have to bring, even government. At the end of the day, any legislative and policy change, we'll have to reach out to government. We have to bring them to that level. Now, having said that, the specific question that was posed by Shantanu to me was like how, broadcast industry or media and entertainment industries in general is managing, licensing and copyright enforcement on the digital front. I think to the extent of, if I may say, fourth generation technologies like application ecosystems like Play Store, iOS and all, I think the licensing and enforcement frameworks are more or less sorted. There is definitely a lot of problem with regard to international enforcement. Because what happens is what we see is differential copyright protections available across jurisdictions. To the extent, if I may say, even in the case of North America, the situation of protecting online content is actually worse off than in India, right? In India, you can have a site blocking order, and then you can dynamically enforce it to whatever URL, whatever DNS that the person recreates, right? But nothing of that sort is available in North America. Over there, I think government of India will have to realize that as differentiated from patents and all, India has a tremendous copyright industry. Print, radio, television, films, digital content, you name it, and probably we are the highest producer. We just keep on churning out content. And over there, we'll have to adopt an approach where we support our copyright industries globally, just as in certain Asian jurisdictions, South Korea and Japan have started doing, where government has realized that they have to enforce the rights of their creators and producers globally, and they have taken it up on international forums as WIPO, and even in bilateral forums with other governments. Thank you.
Thank you. Thank you very much, Naveen. It is very interesting. Of course, his view is that the topic is outdated, and I have to agree with him if I'm sitting only in Delhi, if I'm thinking only of the metropolitan cities in India. But if you broaden it and think of the entire India, there are areas where this topic is relevant, where the mismatches that some areas we are very, very advanced. You're talking about perhaps what you meant was the multi-service interfaces, multi-service, when copyright issues get involved into multi-service interfaces played with 5G coming in. There are, as you talked about, automation to and fro in multiple ways. This is definitely being discussed quite a lot in Europe. And whether it is Telefonica, whether it is Deutsche Telekom, whether it's quite a few others, Orange, I'm trying to see from different geographies in Europe itself. So they are definitely banking on 5G and talking about, yes, of bringing it. So they're talking of multi-service interfaces and how do you handle the copyright issues, and your topic comes in. Of course, the European Union comes in with their directives, very much so. In India, we are neither there totally, nor where we should be. We are sort of in between. That's my understanding. Yes, you will intervene. Hold on. So hold on to your point. So the point is that where should we go? Whether we should really, on the policy side, as you said, that we have on board someone who knows how difficult it was to get the Indian government get into the WPT and the Phonographs Treaty. So, and you very well know too, the point is organizationally, institutionally. Now the point is going to that extent, what should be the timelines that we see? We will come back to you, but before that, one of the persons who was in the forefront right from the beginning when he was looking into other institutions and their rights of the performers, and one of the pioneers now with his institution of ISRA, how it went ahead, whether we have achieved a landmark in making sure that all the performers, the singers, the other actors, everyone gets a share when it is monetized, when the copyright content is monetized, everyone gets a share. Whether we have reached a landmark or whether we have reached somewhere and still a long way to go. I hand over to Sanjay to talk about that.
Yeah, I think the debate is perfectly poised right now. Well, you see, I especially look, let me just give you briefly, I was the one to start off the fight for the composers and songwriters of India to set up their collecting society called the IPRS, which is now recognized as the Indian Performing Rights Society, to look after the copyrights of the composers and the songwriters. And I was associated with the 2012 amendments. I was in the drafting committee and so on and so forth. So I have the inside view of what happened there. And now, of course, I have started off this organization for the copyrights, to collect the copyright royalties for the performers, especially the singers in India. The Singers, the Indian Singers Rights Association, as it is called, ISRA. Now, of course, these are very exciting times. Number two is that we are in an evolution stage, so we are obviously going to have such issues emerging. And let me tell you, as far as the changing times are concerned, yes, of course, not only the users and the technology companies, but even the owners or the creators have also moved on from the traditional so-called copyright, as Naveen was saying, to the multimedias and the other things that are happening today, the services, multi-services, and so on and so forth today. What exactly is the issue is that one is a fact that we all need to know, and we all know, I suppose, is that technology is way forward and way ahead of copyright. That's everywhere in the world, not only in India. So if that is the case, of course we do as copyright owners, as copyright creators, we do need to catch up with that. Coupled with that, in India especially, what has happened is there is a lopsided development of the entire industry. What has happened is everybody wants to make money, but no one wants to share that with anyone, right? So whether it be organizations earlier in the case of creators, where it really struck off the note to have this concrete law of 2012, or even from various broadcasters, radio broadcasters, television broadcasters, internet platforms and so on and so forth, to really be not aware. Of course they are aware because they have huge legal guys like all of these guys here, but they need to be emotionally aware of the fact that they need to pay something. Content is not free. Content should not be free. If it is free, I think it's their responsibility to say that they don't make it available free. Because of the fact that if content is free, the creators will no more be there. We have a responsibility to see as a country, as citizens of the country, to see that creativity doesn't die. If creativity dies, none of this will exist. Okay? So let us not speed that end into the whole thing. Let's go step by step. Let's go, and that's the reason why 31D came into being. 31D was the result of the fact that the owners became too greedy, and they started arm twisting the broadcasters. Well, that's not done. It's business at the end of the day. Okay? The businessman needs to make his money. The owners also they need to make their money. And now I think the next round of amendments will be to really get into being some provisions to get these broadcasters and the users into foray. Because now the broadcasters and their users are becoming too greedy. So one, the law, the policy, the government has really reined the owners to the extent, listen guys, if you're going to be too greedy, there'll be law on you. And I think the next round of negotiations and the next round of amendments will be to rein in the users. If the users start saying that, no, we're not going to pay for it, or for every little 1 rupee or 1 paisa that a person is going to charge, they're going to come up with saying, oh no, this is too huge. Boss, please look at your revenues and then talk. So the point is, in India especially, if you talk to the users, well, Mr. User, we do not want a single rupee from you extra. That is my policy, the ISRA policy. The ISRA policy is very clear. Don't pay us if you don't make money, but do pay us if you make money. That's the ISRA's policy. But when we say that, which means, okay, let's share in your revenues. Oh, we don't share our accounts. They are confidential. Now, how do you expect us then to license you? That's the biggest problem. You know, the users here, especially in my case, is the performers, the singers. We are ready to do that. No problem. Why should we even ask you to pay something for which you're not making money? But obviously, the users, the singers or the performers or the copyright owners are not here to fund your expenses. Similarly, as the broadcasters and the telecasters are also more concerned with their broadcasting signals. And we are with them for that because we fall under the same category called the neighboring rights, right? So the broadcasters and the performers are called neighboring rights in technical terms. And therefore, we need to protect this and enhance this further for both of the people, the performers as well as the broadcasters, to really make some mark in the future and go steady on that. So that's my take on the entire issue. And if there are any questions, I'll be more than happy.
Thank you, Sanjay. Thank you very much. Of course, questions will come, especially when I'm very curious as to how much you are able to recover the proportionate monetization, of course, from the agencies like the mobile phone service providers. And then, hold it, so these questions come that, of course, you might get from very institutional bodies where it is easier to get the royalty. But what about the mobile service who are using your music, you're using your content, and also FM radios, maybe, perhaps. I will stop at that because he wanted to intervene if you still have your point, and then we'll open it up for discussion because we are running. Yeah.
Just to respond to your viewpoint of, that probably the debate remains relevant to maybe not in metropolitans, but outside, just that limited point. I think what we see in studies and what we see as recurringly what data proves is that our rural populations are far more eager to adopt technology if the price point is right, far more than our metropolitan populations. It'll be kind of a revelation to a lot of people, but online video is consumed many times more in rural India than it is done in metropolitan India, simply because the numbers are way more. The number of users are way more, right? So at the end of the day, because of the cutthroat competition in the telecom market and the entry and the entry of convergence, triple play, four play players, what will happen is that price point will be achieved far faster than it was achieved in traditional technologies, such as your landline telephony and all. It will be achieved like probably the factor of differentiation would be 100, 200 times. It will be achieved in no time. Even today, less than half of the world's population has a fixed line telephone, but a great chunk of global population has a mobile phone.
Thank you, right? Naveen. The question still comes, the protection.
Yeah, coming to protection. So every discussion on protection of creators' rights, performers' rights, producers' rights, and also balancing it with public interest, we cannot only look at it in terms of urban populations and rural populations.
Right.
We'll have to look at it in a converged scenario.
But the protection, the lapse of protection or the insufficient, ineffective protection still carries on. So that's my point, whether it's rural or whether it's urban.
Absolutely, that's a point.
But we'll open the floor for some questions, and then we'll come back to you, Sanjay. Any questions? Yes, please. Can someone give?
Hi, this is Advocate Amar Saini. I am chairman of my AG Global Law Firm with my partner Jolie. I would like to ask the question that the sir was saying, that new amendments have taken care of various loopholes which were there earlier in online copyrights and other areas. I would like to know that what kind of litigations are coming nowadays in the light of the violations of these copyrights.
Well, as I said, it's exciting times, more exciting times for lawyers. So yes, a lot of litigation is already there, more to come. And every piece that has been legislated now needs to be more evolved, needs to have more clarification. So for example, the one I can just give you an example of is the right to receive royalty. Now what really the 2012 amendments brought in for the artists of the country, because earlier the same type of what we, as I had sort of negotiated and impressed upon the parliamentarians and so on and so forth during my 5 years of hard work there to get the law amended, was the aspect that in the industry, in the music and film industry, there is a system of, you may not call it that way, but there exists the system of zamindari. Okay? The artist is given a blank sheet of paper like this and asked to sign this. Sign this or you're not getting it. You're not getting this job. So this exactly resulted into a zamindari system, bonded labor. So we needed to sort of stop this bonded labor from happening. And therefore the 2012 amendments that were brought in this very important feature, which is that irrespective of the assignment of copyright to the assignee, the artist will still be receiving his right to receive royalty. Now, unfortunately, the law did not define what is the right to receive royalty. Now that is left to the courts. So such small little things, etc. But yes, as I said, this was a constructively devised destructive mechanism in copyright legislation of our country. The reason is very simple, because one is either you reconstruct a particular building, or you just bombard it, bring it down, and raise it again. I suppose we did that. So it has to be raised again. And in this raising, there'll be many number of clarifications, many number of ambiguities, etc., which needs to be clarified. And that's where I think the legal fraternity also needs to help that come up, whether it's on whichever sides, that doesn't matter. What matters is that the clarity needs to come in, and the courts need to give that. So there's a lot of litigation going on, and I think that'll evolve.
Yes, let me take it. It's not a question of loopholes. The 2012, it was, as they said, that trying to cope with the advancement in technology that has gone in. Statutory license is only one part of it. The point is TPMs, whether breaking of TPMs would be whether it be a violation of the copyright. That was not there. The issue of broadcast, whether broadcast copyright would cover content which is going on broadcast. These are some of the, so it was trying to cope with the advancement which was going on. It's not necessarily loopholes issue. The point is, what he mentioned is one aspect of it, that if you talk of the same thing, if you talk in analogy with the patents, the issue of access and benefit sharing. And benefit sharing with whom? Benefit sharing with all the others. That's what he said. He has his perspective on that. But perhaps, just to give a legal perspective, can you, Rodney, can you just touch upon the Lahiri, the ongoing Lahiri or recording case 31-1, I think 31-1 and 31D, 31-1B, sure. I think 31-1B, and just touch upon them.
Sure, very briefly, but just...
if you have an opposing view or anything, please.
No, 45 seconds to agree with the important points that Naveen brought forth, especially on the EU copyright directive. And I think that
Absolutely.
If we are looking for parallels within the intellectual property system and comparing it to patents, I think there's a bigger parallel with privacy.
Absolutely.
Because we have platforms which are controlling the privacy marketplace and privacy governance. And we see those very same platforms, with the greatest of respect and admiration for them, controlling the online copyright and intellectual property ecosystem as well. The challenges to 31D have been quite a few, and the Lahiri case is important because not only has it been challenged under the Constitution, but importantly, I note that in the last hearing, the government refused to be served. So what does that mean? Does it mean conceding of ground, or does it mean now that fresh things are about to happen?
You keep it open-ended. I open up that's very interesting. The case is going on. So he kept it open-ending with his last question. So the point is, well, before going into further details, any other question, any other comparative from other jurisdiction, before I request the panelists to close with a remark as to where you see we are going, what are the areas that need to be looked into, even from a policy perspective, and what timelines you would give to close those issues. May I start with Sanjay, perhaps? Sorry, Sachin. I'm sorry, Sachin.
As I told earlier also, we need to see how 2012, you said bundle of things have come up, but there are many things which issues are still on the pipelines, where I told Copyright Board need to function properly, things should be managed by them also. Appellate Board should be up there. No one, everyone what doing, anything which is coming is going to High Court, and High Court's putting up a stopper to that. It will take long time again, which is pending since long. Things will not change, need to change effectively. Enforcement drives which are there, which is lacking, is one of the pace which is required. Enforcement not in metros, in all total areas, because copying of everything can be done in a flick of time. Today, Netflix is there, Ghana.com is there, for those all broadcasting, which subject we are talking about. In seconds, you can copy it and use it. then how to use the enforcement. Enforcement agencies to be built in each district, like we have cyber crimes also. Similarly, IPR bodies should be fit in each district all over India, so that IPR crime can be stopped. That's what from my part.
Thank you. Sanjay, any comment?
Yeah, I think the way forward is one is of collective administration of copyright. That's the most important one here because, as you rightly said, that is the bundle of rights. Now, to get clearance of bundle of rights becomes a very, very important issue, crucial issue, and a complex issue for the user. And therefore, what is important is the collective administration of copyrights should be really streamlined. As far as the collective administration of copyright, therefore, the societies in India which has registered to look after different sectors of copyright have to be very responsible to come out with affordable, as Naveen was saying, affordable rates.
Thank you.
For a particular thing.
So the timekeeper's flag has gone very high.
Yeah.
Rodney, you have already covered. I think Naveen, very quickly. Naveen.
And I will ask Sarmil Bhushan to present a memento to our esteemed speakers. I'm being rude. I'm sorry. But
No, this is not a question of rude. I do understand your time pressure, but the audience would like to listen the last comment from him, not from me.
We would have finished by now.
So give the audience a chance to hear him out.
Just 2 points I would like to leave the audience with is, in copyright, I think the 2 debates that will capture global imagination. One will be the differentiation between content application layer and the infrastructure network layer. And the second would be balancing of producers' rights, performers' rights, and public interest. And that's where all of us will have to keep our eyes open, eyes, ears, all our senses open.
we have
Thank you.
very
Thank you
beautiful. He is being one of our founding member of INBA. We have.
So I have to say that the timekeeper came 2 minutes before. So if you look into your time, the radio time, you'd see that we have covered and completed at 12 o'clock. Thank you, timekeeper.
So thank you very much for your cooperation. We understand it's very difficult for me as well to interrupt, but I have to.
We will start the next session in 5 minutes. Thank you.